Hello everyone, welcome to our talk. I am Mang Cai, PhD, JD, attorney at law at New Weiming Law Group. So today my topic is denial without RFE, the new policy. Well, as we know, the USCIS recently issued some new policy memos which caused tensions from the immigration community. And the other day we recorded a video discussing the policy regarding notice to appear. Basically, if the application is denied and the applicant does not have any other legal status, the applicant may be subject to removal proceeding, but that's only probably in some rare cases or with certain specific type of applicants. You can check our other video for more information. And today, we're talking about the USCIS issues new policy memorandum on issuance of certain RFEs and NOIDs. Basically, the USCIS or specifically immigration officers may be able to deny some cases without issue the RFE or NOID first. And this guidance is supposed to be effective by September 11th of 2018 of this year. So the background information is previously, back in 2013, the policy is the USCIS should receive and adjudicate or process all the applications unless the application shows there's no possibility of approval in a glance. So because of such policy, USCIS often needs to send out the request for evidence or a notice of intention to deny first. And then if does not receive satisfactory response, the USCIS can then deny the application. Well, in order to streamline the processing under the new memo, when it's implemented, the USCIS will be able to deny the case without first issue RFE or NOID. Of course, that caused some concerns, and there have been widespread reports, and some of our clients quickly asked us regarding this question, so we recorded this video to clarify. Okay, we want our clients and most applicants to rest assured, because as the American Immigration Lawyers Association has analyzed that the new policy is not intended to penalize filers for innocent mistakes or misunderstandings of evidentiary requirements. So what this policy is intended is to discourage frivolous or substantially incomplete filings used as a placeholder. Okay, so when or why would this happen? Well, for example, there's one applicant whose application under the normal conditions have been denied, and this applicant does not want to give up, so he just files some frivolous application to hold a place. So while the application is pending, this applicant may still be able to stay in the US. As we will see, there are some examples given later. In some other examples, maybe one applicant wants to get ahead in the queue, so he or she may file the application ahead of time, even though the supporting materials are not ready. So this will give the applicant an earlier application date, and several months later, maybe the applicant will gather all the supporting material and submit those upon request by the USCIS. Of course, this is unfair to others who played by the rules and submit the application when the package is all complete. So now let's look at some specific categories and examples. Okay. One category is so-called statutory denial, where the memo gives some examples. For example, for waiver application, there's extreme hardship waiver application with the form number I-601. Well, this type of application is to ask the applicant to prove that if the applicant has to leave the US, this will cause extreme hardship to his or her immediate relatives, like spouse and children, who are US citizens born in the US or who are US permanent residents. Well, if instead the applicant submits an application saying, look, if I have to leave the US, a relative of mine living abroad who's not a US citizen will feel sad. well, this is not sufficient reason for the approval. So if such kind of application is received in the future, USCIS may deny it directly. For another example of the statutory denial, well, if there is an applicant who says, oh, I want to file a family-based immigration petition for my cousin, well, this is not a category that is authorized by the statute, by the law. So such kind of family-based application for the cousin will be denied. Well, similarly, like a U.S. permanent resident cannot file immigration petition with the beneficiary being their siblings. Well, if such kind of family-based petition is filed where it's not authorized by the statute, it will simply face a statute denial. Another category is denials based on lack of sufficient initial evidence. For example, again, if someone submits a waiver application, I-601, well, he or she submits a form, but there's no supporting material. Okay, such kind of application, in the past, you may receive a request for evidence, so you can submit the evidence later. But in the future, if you simply submit a form without any supporting material, the application may be denied outright. Then for another example, for family-based application, well, usually there will need to be an affidavit of support with the form number I-864. Okay, if you file a family-based application, say, for example, for your parents, but you do not provide a support form to promise that you will provide this financial support for the beneficiaries. If this essential form is lacking, the application may be denied outright. So from these examples, well, which are used in the actual memo from the USCIS new policy, we can see, well, the focus is on, hardship waivers, family-based immigrations, maybe asylum, those kind of applications. It's not mainly on employment-based applications, or especially, our client base, like EB1, NIW, or PERM applications. Well, I'm not saying, EB1, NIW, or PERM applications will not be denied, but as long as you prepare the sufficient supporting material and apply, based on the right category, the risk of denial is pretty low. As you know, even if, God forbid, the case is denied, there are still some other procedures, including I-290 form for motion to reopen, motion to reconsider. We have filed such motions and received approvals for both I-140 and I-485 cases. And besides those motions, you can also file the appeal if you receive an adverse decision which you think is unfair. So, there may be some positive side of this new policy. As we mentioned in the past, there are some people who simply abuse the system. They may file application even though there's no merit. Well, when the application is pending, the USCIS will take the time and the resource to adjudicate the case, which may delay overall, processing time for everybody. And this may be unfair for others who played by the rules. As we summarized, there have been, some news reports, especially using scary titles, warning that there may be more denials without RFE or NOID first. As we can see, based on the examples we have given, it's for people who has missed a lot of important supporting materials, or applicants who apply based on some category which is not allowed by the statute. Okay? And on the other hand, the normal application should be fine. And of course, when you prepare the immigration petition, you really need to pay attention, make sure you fill the form correctly and include the supporting materials as needed. And of course, if you have additional questions, or if you are not sure, about this application, which the USCIS is getting more strict with its policy. So, if you have concern, you can surely contact us to have your questions answered. And we are happy to help you to prepare all kinds of applications to avoid trouble, to problem. So the take-home message is the so-called denial without RFE. Well, technically, this is a policy towards being more strict in the adjudication of cases. But usually, if you have things ready for your application, you don't have much to worry about. Okay? If you have additional questions, please contact us. Thank you.